We're back in the ABCs of environmental law. We're still in the B's, and today's B is a really big one for anyone investing in a commercial or industrial property. It's the BFPP, the Bona Fide Prospective Purchaser, which is one of the most powerful liability protections in environmental law. And people often get this wrong, and there are big consequences to not getting it right. So we start by talking about CERCLA, a federal law, the Comprehensive Environmental Response, Compensation, and Liability Act, and you probably know it as Superfund. But under CERCLA, you actually can buy a contaminated property and not be liable for cleaning it up if you qualify as a BFPP, and that is a big if. To get that protection, you have to do proper due diligence before you buy. It's typically a phase 1 environmental site assessment with a qualified environmental consultant, and it's going to meet certain really stringent requirements. And if there are red flags, you may even have to go farther to get a phase 2 and actually do some sampling. You also have to comply with a set of ongoing obligations after closing, and those are going to include things like taking reasonable steps to stop ongoing releases, stop exposure, you're going to cooperate with regulators, and you're not going to make the problem any worse. And where the deals fall apart is that people think a BFPP is automatic. If they didn't cause the contamination, they're just buying the property, they shouldn't be liable. And that's not true. If you miss a step, if you didn't look into things before closing and have a reason to purchase it not thinking that it was contaminated, you may miss out on this protection altogether. So the bottom line is that the BFPP can be an incredibly valuable concept, but it is not a free pass. Most people get it wrong, and it's a strategy that has to be executed correctly from day one before you even buy the property.